This courtroom drama takes a wild turn when self-proclaimed sovereign citizen Beth Bridgman walks in and immediately challenges the judge's authority. From the very first moment, she insists she's making a special appearance, and claims she's not the legal name written in all capital letters, but a living soul. The tension rises fast as she repeatedly interrupts the court, refusing to waive any rights and questioning everything the judge says. But the situation gets serious when the judge outlines 2 contempt charges against her. First, she's accused of unauthorized practice of law after allegedly interfering with another defendant's access to his attorney. Second, she's charged with failing to appear at a prior hearing, and even tearing up the court's show cause order. The possible penalties: up to 93 days in jail and a hefty fine. Instead of backing down, Bridgman fires her appointed attorney right there in court and declares she'll represent herself. She argues that her common law rights have been violated and claims the charges keep changing. The judge patiently explains the rules, denies her request for a jury trial, and schedules a new hearing, making it clear that self-representation comes with strict conditions. Then comes the bombshell. A $10,000 bond is set because the court believes she might refuse to appear again. Bridgman protests, saying the bond keeps her under the court's jurisdiction and questions how state laws can override the Constitution. The judge firmly responds that states have authority to create and enforce their own laws. And in a twist many viewers found ironic, the same person rejecting government authority is reportedly receiving government disability checks. This isn't just a hearing. It's a high-stakes battle over authority, accountability, and the limits of courtroom defiance.
Hearing upstairs in the circuit courtroom is being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as arraignment attorney on behalf of Beth Bridgman.
Although I will represent myself.
Yes,
okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving.
Or sit, whichever you're more comfortable with.
I don't know how I would pull a chair up, so thank you.
Well, if you want to sit there, I have no problem. All right.
Thank you.
Okay. All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt, so I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted, and then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations, where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know? Well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt citations. The rights that you have that I outlined for you and the maximum penalties I outlined for you.
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, that I believed she was going to let you know. She was collecting information. Did you just understand that I think there's a bigger overriding issue? Thank you. Thank you.
I'm not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already.
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between you and Ms. Bridges.
I guess I just like to, state that.
Well, I think you need to back it up.
Pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future hearing.
No, that all of my rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She was working. Okay.
Okay, you're going to get your
Mr. Villanueva,
no, this is.
Stop arguing with Ms. Bridges.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right. If she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
she was investigating. Okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have a cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed, Judge?
I'm not answering that question.
Can the prosecutor?
No.
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes,
okay.
I do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are
if
those,
you refuse, then I'm going to appoint
I'm not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so
Okay.
I'm asking you, and you saw what
How
happened.
can
I have
I,
to make sure you know what the maximum penalties are and what your rights are. Do you not?
those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over a $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's
common law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty. That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing,
I've told you what you charged. I can read it again if you want.
or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will. I'm not
Okay,
gonna argue
and
with you about what-
And the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now,
What is
Okay.
what one do you have?
and this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items checkmarked here.
This is after the fact, so then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more.
This courtroom hearing begins with immediate tension as self-proclaimed sovereign citizen Beth Bridgman approaches the bench with visible confidence and zero hesitation. Before the judge can even fully settle into the rhythm of the proceeding, she makes it clear that she does not recognize the authority of the court in the way an ordinary defendant would. She announces that she is appearing by special appearance only. She refuses to identify herself in the standard legal sense. She insists she is not the name written in all capital letters on the paperwork, but instead a living soul. Right away, the courtroom dynamic shifts. The judge remains calm, measured, and patient. He allows her to speak, but he also makes it clear that the court operates under established procedures and statutes. While Bridgman continues asserting her sovereign status, the judge focuses on the matter at hand, two allegations of contempt of court. The first allegation is serious. According to the court, Bridgman engaged in the unauthorized practice of law. The judge explains that she allegedly interfered with another defendant, Seth Flores, and prevented him from properly meeting with his attorney. Interfering with attorney-client communication is not a minor issue. It strikes at the core of due process. The court views this as conduct that disrupts judicial proceedings and undermines a defendant's constitutional rights. Bridgman does not accept this characterization. She questions the accusation and implies that she was acting within her rights. But the judge firmly outlines the boundaries between personal advocacy and licensed legal representation. The second contempt allegation stems from her failure to appear at a previously scheduled show cause hearing. The judge explains that she had been ordered to appear and respond, but she did not comply. Even more concerning to the court is the claim that she tore up the show cause order. That action, if true, signals direct defiance. The judge makes it clear that ignoring a court order does not make it disappear. It only escalates the consequences. He carefully states the potential penalties. If found guilty of contempt, she could face up to 93 days in county jail and significant financial fines. The weight of possible incarceration hangs in the air. But instead of retreating or reconsidering her approach, Bridgman doubles down. She argues that a state trooper told her the show cause order was invalid because she was not under bond. She suggests that without bond conditions, the court had no jurisdiction over her. The judge listens but responds by explaining that jurisdiction is not erased by personal belief. Courts derive authority from state law, and individuals cannot simply opt out because they disagree with the system. Then comes a dramatic moment. Bridgman dismisses her appointed attorney in open court. She announces she is firing counsel and will represent herself. The judge pauses to ensure she understands what that means. Representing oneself is a constitutional right, but it comes with strict obligations. He warns her that she will be held to the same standards as a licensed attorney. She must follow procedural rules. She must file documents properly. She must comply with deadlines. There will be no special allowances for misunderstanding legal protocol. She insists her common law rights have been violated. She repeatedly questions whether the charges have changed. The judge clarifies that the allegations remain the same and carefully restates them to avoid confusion. He wants the record to reflect that she understands exactly what she is facing. At one point, she demands a jury trial. The judge denies the request. He explains that contempt proceedings of this nature do not carry an automatic right to a jury. The decision rests with the court. His tone remains steady, professional, and unwavering. As the exchange continues, Bridgman circles back to constitutional arguments. She questions whether Michigan statutes can override constitutional protections. The judge responds with a fundamental explanation of federalism. The Constitution establishes the framework, but states possess authority to enact and enforce their own laws within that framework. State courts operate under that delegated authority. Her disagreement does not invalidate the structure. The judge then schedules the contempt hearing for January 25, giving her approximately 3 weeks to prepare. He outlines the process she must follow if she intends to call witnesses. Subpoenas must be requested through the court. Documents must be filed properly. She cannot simply bring people to testify without following procedure. The discussion then shifts to bond. The judge expresses concern about her prior failure to appear. Given her statements rejecting jurisdiction, he believes there is a heightened risk she may refuse to return. For that reason, he sets bond at $10,000 cash or surety. The number lands heavily. Bridgman protests immediately. She claims the bond is another mechanism to trap her under court control. She argues that it reinforces jurisdiction she does not consent to. The judge clarifies that bond is not about control, it is about ensuring appearance. Courts routinely set bond to secure compliance. Given her past conduct, he believes it is appropriate. Throughout the hearing, the contrast is striking. On one side, a judge operating within established legal doctrine, calmly reiterating procedure and statutory authority. On the other, a defendant rooted in sovereign citizen ideology, asserting independence from governmental systems while simultaneously standing before that very system. The tension builds not because of shouting, but because of irreconcilable perspectives. Bridgman views the courtroom as an arena where she can declare separation from state authority. The judge views it as a structured institution governed by rules that apply equally to all. As the hearing moves forward, the irony becomes impossible to ignore. Despite rejecting governmental legitimacy, it is mentioned that Bridgman receives government disability benefits. The contradiction underscores the complexity of sovereign citizen philosophy, rejecting authority in theory while interacting with government structures in practice. The judge never raises his voice. He never appears rattled. Each time she interrupts, he waits. Each time she questions jurisdiction, he responds with grounded legal explanations. He ensures the record reflects that she has been informed of her rights, informed of potential penalties, and informed of procedural requirements. By the end of the session, the outcome is procedural rather than dramatic. No final verdict is issued. No jail sentence is handed down that day. Instead, what remains is anticipation. A contempt hearing is scheduled. Bond is set. Conditions are clear. The stage is prepared for a future legal confrontation. This hearing becomes more than a dispute over contempt. It becomes a case study in what happens when deeply held personal ideology collides with institutional authority. It shows how courts respond to sovereign citizen arguments, not with debate over philosophy, but with steady adherence to statute and precedent. For viewer, the hearing is gripping because it exposes the real-world consequences of legal defiance. Belief alone does not dissolve jurisdiction. Paperwork does not vanish because it is torn. Court orders do not lose power because someone declares themselves outside the system. And as the date for the contempt trial approaches, one question lingers. Will ideology continue to guide her strategy, or will the weight of potential jail time shift the course? The courtroom will ultimately decide, not based on declarations of sovereignty, but on evidence, procedure, and law.
Please, Judge Gothier.
Sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original show.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would Your Honor like to see what she has
But-
here?
I just, so
Okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury
for
in
a contempt charge?
So
Oh, so this is a perfect, nice little tidy package for everything. I see.
January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then. That gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long as I'm convinced that you're doing so of your own free choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If you want to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out.
Oh, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay, I get it, Judge Gothier, I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? Recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Richmond is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Richmond's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training in researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yet, Ms. Bridgman, if you want to represent yourself, it's a little bit more work. You're gonna have to-
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I would
Right.
review. It'd be the district court office
Okay.
that I would review, and I would issue the subpoena. If it's
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association, am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have arranged.
I
on the
get it,
charges to
but
set
I
the-
appreciate that this is very big in scope and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
She's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. of course.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right.
That's
so
why it's called common.
You set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? A lot of people
Well, I can
struggle with
recommend a
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor,
as a
part of
bond
the-
question, any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf, would you like to-
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city, not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the the Sheboygan County for that. And so I advise that Your Honor, oh, and one last thing, she's a politically active member in the community. She has audited an election previously. So I believe, she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut off the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they didn't.
An offer, it was an order
Sorry.
to appear.
They didn't actually hand it to me.
Just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety the full amount. There will be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change your, we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to go today, Mr. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's right. All right, we'll adjourn.
No. This way.
I know. She's only up here from North Carolina. Work with all you guys.